All right, welcome everyone. This is Curt Verone.
And Brad Pinsky.
All right, and we are here for another edition of Fire Law Roundup for this time for May 15th of 2023. Brad, take us away.
All right, well, you posted one last night. I love this, and I will just say, if anybody wants to do this in New York, I am your guy. I love this suit. I initially thought it was kind of ridiculous, and then I really started looking into and thinking about it. So we're going to start in Los Angeles, and Los Angeles County is being sued by a number of people, but presumably or primarily, I guess we'll say, by because they're John Does, you don't really know exactly, but it's a class action by students who were at the academy, and they were told on, let's call it off-duty hours, that will be the question, to quarantine during COVID in their rooms. So to be clear, according to the complaint, they were not allowed to leave their rooms, thus restricting their activities. And there certainly is a lot of discussion in the Fair Labor Standards Act about whether you have to be paid for off-duty time. We call it waiting time, which is time in between job duties. Let me give you an example here, because this is a good one. So person number one drives to an appointment in city number one, and that appointment is done. And then there's another appointment in city number two, but he's got a couple of hours to do what he wants in between. As long as the employer says, hey, do whatever you want between those two meetings, then no, there's no compensation requirement. So waiting time. But where your activities are restricted in that regard, there would be compensation due. And I didn't see this in the complaint, but I thought I'd look this up. And this is really located, for those who want to read this, in volume 29 of the Code of Federal Regulations, section 785.14, all the way to 0.16. So what those sections say, and I presume where the lawsuit's going, is, listen, by restricting us to our rooms, we were not free to engage in off-time activities, right? You restricted our activities. Yes, we could do whatever we wanted in our rooms, but you told us where we had to be. And there's a lot of on-call discussion and things. If that's true, I think this lawsuit has very much a good chance of winning, and I want the same one. So anyone in New York, feel free. I'll sue on this.
Yeah,
Curt, what do you think?
I think this is the suit that we've been waiting for. Way back when we first started having the quarantine problems, it actually went back to Ebola and before COVID. There was some concerns about what happens when you tell a firefighter to quarantine. And there's a general principle in the FLSA that the employer is only obligated to pay for work. But there's a little bit there's a big discrepancy, because it sounds simple, right? If the employer requires you to do something for work, then they have to pay you for it. Sounds simple, okay? The problem becomes is, what happens when I tell someone you have to shave? Or what happens when I tell someone you smell, you got to take a shower?
Or check emails off time.
Oh, well, that's a little bit different now. There's a thing called preliminary and post-preliminary activities and so on. Checking your email would be more in the realm of compensable. So it very, very complicated. We spent hours going through this in our FLSA class, okay? Bottom line is, I've been waiting for this case, and it just never came, and I couldn't believe that it hadn't come. Now it comes in the form of fire academy students quarantined at a hotel. And I know you don't practice in this area, and there's a lot of sort of trap doors and mirrors, and very, very difficult to navigate around. There's another section in the and you will certainly, what you just said is exactly what they'll be arguing, that they told us to go to this hotel. When your employer tells you to do something, your employer tells you to go stand in the corner for 8 hours, you got to pay them to go stand in the corner for 8 hours. That makes sense, okay? There's another section, and this is what makes the FLSA so difficult, is there's a section in there, section 29 CFR 553.226 on training time. And within that 553.226 is exception C. What we call in my class, we call it exception 6, because we teach there's 6 exceptions to the training that you have to pay someone to go to training. And this is one of them. It's called the Fire Academy exception. And so that if you are assigned to an academy and you are required to go there, for example, you're required to go to the State Fire Academy. Many state fire academies have a live-in program. The National Fire Academy, you may be required to go there if you're a fire investigator or whatever, you're required to go there. The exception in 553.226 says that unless you're in class, even though you're required to be there, unless you're in class, the time is not compensable. But
here I think there's a nuance.
Well, there's a lot of nuances, okay, and right. there always is, and that's going to become the battleground. So I guess to sum up where I'm at with this, I was really looking for this case to come up, but I wasn't thinking it was going to come up in the context of a fire academy.
Right.
And if there's one area that I think is a definite problem for the plaintiffs, it's going to be the fact that they're at a fire academy.
Yeah, I think the nuance here is that they couldn't leave the room. Because when I first read this, I'm like, oh, come on. It's like you send someone to a conference to right where they have their off hours. But if they were truly told you're not allowed to leave your room, that's the factor that I think, right? You have no free time anymore.
It could. The question and the way that it's worded is, are they free to pursue personal pursuits, or are they free to engage in personal pursuits? So are they free to read a book? Are they free to go on the internet? Are they free to watch TV? Are they free to take a nap? Okay, now compare that to maybe a police academy. I know our state police academy is a live-in academy, and at 2 o'clock in the morning, they'll roust them out and they'll go for a 2-mile run. Right. Okay, or they'll get up at 3 o'clock in the morning and do calisthenics.
And they got to be paid for that.
Absolutely. That's my point. That's the kind of control I think that you're looking for to get around this fire academy exception. But when you are pretty much free to do as you choose, now, again, within limits, okay, and this is the same thing on a deployment, which, I was a USAR task force leader, and this is an issue on deployments as well. You're deployed to Hurricane Katrina, you're down in Mississippi, or you're on a wildland fire out in Montana, you can't go home, okay? And you're told, get in that tent, you're gonna, stay in that tent or stay at the base area, but you're not permitted to go to the movies, or you can't go to the convenience store or whatever. You've got to stay in camp. That's fine. It's not compensable as long as you get to choose, do I take a nap? Do I watch TV? Do I write my girlfriend a letter, or whatever it may be, an email, or whatever it may be? So again, a lot of nuance. I was hoping this case was not going to involve a fire academy. That's my point, because I think you take the fire academy out of this, now it's a different thing. Oddly enough, according to the complaint, they paid the instructors 24 hours, which they would have to do because they're pretty clearly supervising what's going on. They would have to be paid 24 hours, but under the fire academy exception there, I don't know. It's interesting. There's a lot of nuance in this one.
If they said they weren't free to leave the academy, I wouldn't have this belief. But when you confine someone to an 8x12 or whatever room,
right?
That to me is so restrictive on your, it's like the paid on call rules, right? Look, if you have to be at a place in a certain amount of time, like 5 minutes or 30 minutes, where they restrict your area, even though you're free to do whatever you want, they got to pay you for that, at least in New York State, because your travel is restricted because you have to be within a certain amount of area. I think if they said you could be anywhere on the academy, do whatever you want, walk around, no big deal, you're free, no big deal. But you start restricting someone to their room, I don't know. That's strange.
That's a great point. And I'm surprised that they didn't allege a California state law wage and hour violations, because California has a lot of protections for employees that go beyond the FLSA.
What if it's
And
a statutory time limit, maybe?
yeah, like this, I'll give you an example. The flight attendants are exempt from the FLSA. People involved in aviation are exempt from the FLSA. But, and just so you know how flight attendants are paid from the moment the door closes on the jet until the door opens on the jet. They're not paid to get there at the airport early. They're not paid to board the passengers. They've got to be on the jet like 40 minutes before it takes off, and then 30 minutes people start boarding and all that. They don't get paid for that. In fact, if there's a ground stop and the door is open, they don't get paid. They get paid.
Now I know why they never want to open the door.
Okay. So that's, and under federal law, they're exempt. So that's fine. Under California law, they have to be paid. Okay, so now there's several class action lawsuits by flight attendants
landed in
were
California,
flying over California, going into California, leaving California. They're saying, wait a minute, under California state law, you have to pay us from the time we got to the airport. We went to our check-in briefing and did all that stuff. Wow. So again, California has a little bit more protection than most states do. And certainly they have more protection than the FLSA does. So interesting case. We'll see we'll keep an eye on it. We'll see how it all turns out.
Well, let's go from that seemingly valid or potentially valid case to one that I'm just going to say, in my personal opinion, is absolutely freaking ridiculous. We're going to go over to Pennsylvania, where families are blaming a hydrant failure on the fire department. They were unable to get water from their hydrant. I mean, there are so many defenses, right? But let me go through it. So they're unable to get water to the hydrant. Obviously, what happens to the house without water? It burns. And the plaintiff claims they lost their home. Okay, that's one thing. But then 8 months later, they lost their wife, and they attribute that to the loss. And I don't think she was burned in the...
No,
right?
It was psychological stress from.
So it's not like she was in the fire and didn't get rescued, but my God, how much immunity is granted in this case? And I don't know in PA if they own the hydrants, right? If there was a failure to maintain.
No, they sued the water department and the township. So they didn't. The funny thing is, I don't know if they were actually going after the fire department or they were just going after the water department and the township. Obviously, the township sort of controls the fire departments. So, but they basically were saying that the water authority was responsible for the hydrants, and the township is responsible for firefighting overall. They pay the fire departments, so the volunteer fire companies, they fund the companies. So between the two of them, they were actually pretty sympathetic in the complaint and also in the videos. They were pretty sympathetic to the plight of the fire department, because they said the firefighters were trying, but there was no water coming out of the hydrants, and folks knew about this. So I don't know, difficult, another difficult case. And I think you're right that you've got first of all immunity, sovereign immunity. Then you have the public duty doctrine, which
definitely
is probably going to be a big factor here as well. So on the other hand, I
couldn't tell if the fire department had the obligation to maintain or inspect the hydrants, but even so, that would have been a spot check. And there's so many hydrants that maintenance of the hydrants is a fiscal activity where you really can't sue. I think it's very difficult to sue.
Yeah.
Okay, let's go back to my favorite issue ever. And this is just a Freedom of Information Act where this comes back to us. We're going back to San Jose to the Pink Poodle strip club. I swear to God,
it won't go away.
It won't go away. And I really want to go to San Jose and just take a picture of the front of the Pink Poodle strip club. So all we have now, the continued saga, is the newspaper under the under a Freedom of Information request wants the disciplinary records, et cetera. And I don't know the law in California, but they've sued under California's FOIA Act, as well as others, and they want the documents, and they want disciplinary records and investigatory material, most of which, by the way, at least under the federal and state of New York, but the federal law would not be discoverable. Investigatory materials that didn't result in discipline and blah, blah, blah may very well not be discoverable. So, but that's where we are. And it's basically a freedom of information request. There is a slow trend. New York, I don't think was the first, but New York, when Cuomo was governor, so about 4 years ago, removed the privacy of paid firefighters and paid police officers' disciplinary records. They opened it up, and so now the public can get the disciplinary history, which is a horrible decision on New York State's part. It's led to a ton of litigation, and right, because you're saying, oh, that cop who arrested me had this much discipline and this file, he was incompetent, whatever. That's what they try to avoid. It's just unrelated stuff to these criminal actions. And that's why a lot of states don't release disciplinary records. And here they're claiming the disciplinary records are subject to FOIL. But here we also might have lack of disciplinary records, right? Now, the fire department, they were coming out, heads are going to roll if we find out this and that. And then they determine, okay, well, there's an excuse. And then they look at the GPS records. Wait a minute, they're stopping. I mean, it keeps going back and forth. But in short, this is just a FOIL request for investigatory records. So this will never go away.
Yeah, there's a balancing, and you're right. In the defund the police movement and Black Lives Matter movement, there's been a conscious effort to remove a lot of the protections that police and fire have, particularly police, but sometimes we get grouped in with them as well. In terms of disciplinary records. And so we're lumped in, and unfortunately in many states, protections have been eroded. Now, the public records laws typically say everything is a public record with the following exceptions, and then it has a listing of exceptions, and discipline records and different things are, but it's the way it's usually interpreted. I don't know about California, but the way it's typically interpreted is literally it's item by item, line by line. It's not a blanket exemption that this entire document, even an EMS patient care report, it's not that you don't have to produce the document, but you can redact, like, for example, the person's name. You can redact their address. You can redact their social security number. Maybe you can redact some medically protected information that's in there. Maybe you can redact almost everything that is printed, okay, but you still have to produce the form. And I think it can be the same thing here with regard to discipline, that you can maybe redact the name, you can maybe redact some of the information, but you still may have to produce the form. Now, maybe different in California. Can't speak to California law, but I know as an attorney for my clients, when we get a freedom of information request, we have myself or an attorney will go through the item line by line, and for everything we redact, we have to state this is redacted pursuant to Rhode Island general laws, yada, yada, yada. Right. You can't just say we're not going to produce the document. So.
Okay, well, we're going to see. Let's go over to Omaha. Omaha has settled a race and gender discrimination suit. What's $275,000, right? That's their settlement. Very reasonable amount. But what I want to point out as I go through these facts, brief facts to the viewers, is look how little it takes to lose a lot of money, right? It doesn't take a whole long history of harassment. So this is a woman, Jane Crudup. She's brought the suit in 21. She was hired as a probationary firefighter, right? And when she's hired, a white officer allegedly, I guess it's allegedly, allegedly told her she couldn't study until after 8 p.m., but then a white firefighter was allowed to study before 8 p.m. And so she alleges disparate treatment. And that's all it takes to say, well, I'm Black or African-American or I'm female and I wasn't allowed to do something that somebody who was white or male was. It doesn't take that much. But there's one little allegation right now. That's not such a little allegation because her ability to study affects obviously how she would do. So then she claimed that a white officer told her to, quote, shut up and listen to what others are trying to say and later allegedly said, you need to learn how to take a joke and laugh at yourself if you want to have some longevity at the fire department. I personally have no problems with those statements.
Mm-hmm.
It seems to me you get somebody who's, just won't listen, or right. I don't have a problem with those statements. I don't think those have any inherent racial, disparity or gender disparity. And then I love this as a legal matter. I love this. Mm-hmm. So apparently she forgot to put her turnout gear away after shift. And apparently allegedly there's a practice among all probationary firefighters, not just women or African-American or whatever. And by the way, I'm not sure I know her rate. Oh, no, she's right, African-American. So apparently this is a widespread tradition. If you leave your gear in your locker, they hoist it from a flagpole. I happen to think that is a great solution. It's okay. It's a little bit of hazing, but is it really that big a deal? Unless, of course, it's pouring rain outside or something. But nonetheless, it was specific to anyone who does that, not just women, right? But there's 3 incidents. Now, she said, by the way, she claims that the hanging or the hoisting and the hanging of the gear was symbolic to lynching. I got to tell you, I don't think so. I think if they put it in a mannequin and hung the mannequin by a noose, and that might be symbolic of lynching. But just hanging your gear, if it truly was, right? If it truly was, but here's the thing: none of those last 2 things I talked about probably would have been an issue, but for the studying comments, but for a white male being treated differently. So it only takes one instance, right, to at least cause all that happened here as they settled. It caused the lawyers to worry about her claim. 3 little, quote unquote, little incidents amounts to almost 300,000. But you take away the comment about race or gender, right, on studying type thing, or the disparity between white and black, and then none of this probably happens. So whoever made that comment cost them $275,000.
Yeah, difficult case. And when I read something like this, my assumption is there's a lot more going on here than what's in the complaint. And I don't necessarily mean more harassment. It could be more harassment. It could be it's actually a lot worse for this woman. But it could also be some issues with her. When you can't get along with one group of people, and then you can't get along with another group of people, and another group of people, and another group of people, at some point, the common denominator is not all of the people that you can't get along with. There's a saying. Let me see if I can get it right. Since this is our show, we can say whatever we want, right? Everyone is entitled to run into one asshole a week. When you start running into more than one asshole a week, you are probably the asshole that everyone else is running into. Okay. And again, I don't know if there was a lot more that happened to her that wasn't in the complaint, that, she really had a legitimate complaint, or, she's only there for 2 years and all of a sudden she's got a problem here. All of a sudden she's got a problem there with different people, not with the same group of people bullying her, picking on her. But, at some point, maybe it's, maybe there's some more that's going on there. So again, from a couple of thousand miles away, it's hard to know for sure, but it's an area that I have a great deal of interest in. It's one of the reasons why I went back to school and started studying forensic psychology, to figure out, do we have toxic people bullying? Is that the problem? We have toxic people in the fire service that are bullying people? Or do we have people who are perceiving things because of maybe some issues in their own personality that may be causing them to perceive things in a certain way? And that's still their reality. I mean, it's not to diminish what their reality is. It is something that officers have got to be aware of, is that people have different perceptions of things. And just because someone's a difficult person, or maybe they have a personality disorder, it doesn't give the culture the right to bully that person or pick on that person. And you've got to actually be very, very careful in terms of how you interact with that person. I think that's kind of summing up what you said as well.
And, there is a psychology to bullying
Mhm.
and hazing, because there's a group, right? We want you to be part of the group.
Yep.
Not that we want you specifically to be part of the group, but we want all new people to fit into the group. They have to bond with us for safety. They have to bond with us, right? They have to show they can be trusted in a fire. So we haze people in part because we want to initiate them and make sure they're worthy of being in the group. And it has these kind of Maslowian thoughts of trust, right? And so I'm not saying it's a valid way to have, I'd rather you just run time trials with throwing ladders and hose and things like that. But I think that's how the fire service thinks of it, that it's right, it brings bonding. Okay, so
that works just so you know, that works with 9 out of 10 people.
It does.
With
Interesting.
9 out of 10 people, that works fine.
Oh.
The other one, and what I'm talking about here is, again, what I've been studying now for the last couple of years is personality disorders. They are going to perceive it. If you have an employee with a personality disorder, number one, they're going to be behaving in a way that's going to cause the other people in the organization to retaliate against them or try to conform their behavior. And then they're going to perceive things in a way that they're the victim, and even things that are not objectively bullying are going to be perceived as bullying. And so we've got to get our officer corps trained up so that they're able to recognize this. And, you know, part of it may be getting some of the people to back off some of the behaviors that they might otherwise exhibit, and also possibly getting the person who needs some help, getting them the help that they need so that they can live a happier and more productive life, whether it's in the fire service or out of the fire service. That's a different story. But there's things that we can do to help them. And to me, why are we talking about this? Because this is what's leading to litigation.
Of course,
Of course. That's what I really want to know. What percentage of our lawsuits are really a function of sort of this dysfunction that we have with personalities?
Oh, ton of them. And don't forget, and I'll end on this, at least my comments, but for this one, you know, people who have been subject to discrimination, racism, bullying, all their lives are primed, right? And I think this is proven, are primed that at the first instance, anything merely reflecting that treatment, oh, this is a continuation. And I'm not discrediting the fact you just have your whole history of life where you're targeted for something or discriminated against or harassed or bullied. And look, it could be because you're short, because you're fat, because you're black, because you're whatever. It doesn't matter. But as soon as something like that happens, it's just triggering the entire past. And I'm not going to take it anymore. And I think when we try to initiate people into the fire service through bullying, hazing, mostly hazing, right? These initiation rituals, we're ignoring the fact that this has a real and serious trigger and impact on people. And it may not be that you just did the one thing. No, this is one thing in a line of their whole history. We just have to stop this. There are better ways to create bonding and teamwork. Okay, let's go to California. Now, you want to see a legit...
Back to California.
Yeah, back to California. I think you said this a long time ago. It's like California cannot get out of its own way, especially Los Angeles. So we're back to Los Angeles, but here we have a jury verdict, right? And we have a jury that's awarded a former fire chief, I think a 30-year veteran, $4.1 million in damages as a result of a wrongful termination. But, and I don't know why FMLA didn't come up. I'll talk about this after.
I was going to say that it's got FMLA written all over it. I don't see an FMLA allegation in it.
Yeah. So look, the short is this fire chief had taken some time off. This reminds me of the volunteer firefighter who takes a 2-week vacation, comes back from vacation. Everyone's like, oh, where you been? You still a member of the department, right? Those stupid comments. But in any event, he has a medical issue, condition, whatever. He takes time off to address it. He, has a disability or perceived disability, and they constantly berate this guy. For example, I pulled out a couple of your examples. So, for example, the president, I think, of the West Covina Firefighters Association says that he tried to use this whole disability vacation or, away from work to get a better result in the city's union contract. And they target him saying, we're going to vote no confidence in this chief after his medical leave. Right. So they specifically went after him. Now they're not the employer, right? The union isn't the employer. So that one's a little harder. But the city's council member, an individual, Tony Wu, he was apparently endorsed by the union, and he called for the chief's termination as an absentee chief. Man, you cannot do that. And as a council person, okay, now this is the government, all right? So he sues under disability discrimination, disability retaliation, whistleblower retaliation, intentional infliction of emotional distress. You can't do this stuff. And I don't have to say that. You don't have to say that. A jury just said it. 4.1 million. The city said, look, we're going. They're normally we're going to appeal. Here you got a very kind of soft shoe. Well, we're going to look at appealable issues and if necessary, appeal. What I presume is going to happen is they'll say, would you take $3 million, right, and save yourself the appeal of losing it all, or $2 million? So now there'll be settlement negotiations. It'll go away, presumably. That was very soft shoe language. But once again, look, if somebody's disabled, if they're a minority, you do not use any of that as a factor. And I was surprised by FMLA being absent from there. That is exactly what FMLA was there for.
Absolutely.
So, and it wouldn't matter that he had a disability, right? The thing with FMLA, it's a medical condition, doesn't have to be a disability. Here, they have to prove disability. So the disability is much harder to prove than a lower standard of FMLA. Anyway, that's all we got today.
Yeah. Is that it?
That's
Wow,
it.
That was quick.
Yeah. Well, when you've got a fire hydrant thing that seems so ridiculous, just fly right through that.
I hear you. So, all right. Well, that's going to do it for another edition of Fire Law Roundup. If you haven't already clicked like, please do, and share also. And we really would appreciate you subscribing. But most of all, we're trying to get our hours up. We're up in the upper tier now with YouTube, but what we're missing now is hours. We need about, I think, 600 more hours of viewership. So if you can maybe go back and look at some archived recordings, we'd appreciate it. And other than that, that's going to wrap it up for another edition of Fire Law Roundup. Brad?